I'm going to discuss about the initiation of criminal case. The person who has interest about the Bangladesh judiciary and court system and trial, those person can continue the video. You know, criminal proceedings may be initiated either with the local police station or with the court of magistrate, locally known as cognizance court. Now, I would like to discuss about the cases which are initiated with the local police station. And whenever a cognizable offense is committed against any person and property, in that case, if any information relating to commission of a cognizable offense is given to police station, either in writing or orally, and the police officer, if records the information, that is, if lodge the FIR, criminal proceedings may be initiated. This type of criminal proceedings, locally known as GR case. And the police laws an FIR under Section 154 of the Code of Criminal Procedure. Soon after recording the FIR, the police send the Ezahar and FIR form to the GRO office within 24 hours. That is, there is a registering officer, and the office of the registering officer attaches to the court premises, which representing the concerned thana. If any criminal case is recorded by any police station, those police stations have a GRO office at the court premises. Within 24 hours of recording an FIR, the thana concerned send the FIR along with the Ezahar to the registering officer, that is to the office of the GRO. After getting the FIR, the registering officer registered the same in a volume, especially prescribed therefore, and FIR, after registering the same, bring it notice to the magistrate. And the magistrate, putting his signature, took its notice that a criminal case has been filed in the concerned thana. And thereafter, the magistrate put the record, that is fixed the record for getting investigation report. And investigating officer has unlimited power under Section 156 of the Code of Criminal Procedure 1908 to investigate offense of a cognizable offense. In that case, the police need not to take permission or approval from the magistrate. A police officer who has been appointed as investigating officer may exercise the power under Section 160 to 173 laid down in the Code of Criminal Procedure 1898. And for purpose of investigation, the rules laid down under regulation number 255 to 289 of the Police Regulation of Bengal. What the investigating officer does at the time of investigation, the investigating officer is to collect the different type of evidence. He may collect testimony, he may collect documentary evidence, electronic evidence, and material evidence in support of commission of the offense. If the investigating officer has been able to collect different type of evidence in support of commission of the offense, in that case, under Section 170 of the Code of Criminal Procedure, he may recommend a prosecution And if he has failed to collect evidence, or if he thinks the evidence collected by him is deficient, in that case, under Section 169, he may recommend not to take cognizance against the accused. That is, he may report not to file a not sent of report, or which is locally known as final report. After conclusion of the investigation, the investigating officer, under Section 173 of the Code of Criminal Procedure, forward a police report, forward a report on a police report, which is locally known as charge sheet, to the magistrate concerned, who has power to take cognizance. You know, in the investigation report, that is in the charge sheet, there is two type of report: sent up report under Section 170 and not sent up report under Section 169. Why there are two reports in a report, or in a charge sheet or a police report? As because suppose 5%, there are 5% against whom an allegation is lost with any police station. But after investigation, if the police officer, that is the investigating officer, may find that only 2% have committed the offense, but rest of 3% did not have any kind of involvement with the commission of the offense. In that case, the investigating officer may recommend prosecution against 2%, which is called sent up report under Section 170, and may not recommending the prosecution against those 3% against whom he fails to collect sufficient evidence. That is why there are two reports in a charge sheet. One is recommending prosecution, and another is not recommending prosecution, which is locally known as final report. However, after getting this police report, the magistrate may take cognizance of the offense against all those accused persons, though the investigating officer recommends exoneration of 3, for example, out of 5, or may take cognizance only against 2% against whom the investigating officer recommended the prosecution by exonerating the 3 out of 5. This is the procedure. Or sometimes the magistrate, if thinks fit, he may send it for further investigation. And if the case is sent on further investigation, then again, on the basis of the police report or charge sheet, the magistrate may take cognizance of the offense. Then, this is the second stage of a criminal trial. And thereafter, the record may be fixed for taking cognizance. This is the third stage of a criminal trial. And after taking cognizance, if the magistrate finds that someone among the accused has not been arrested yet, though the magistrate has taken cognizance against him, in that case, the magistrate may take steps under Section 87 to proclaim him fugitive or absconding under Section 87, giving him 30 days to appear before the court. If the accused fails to appear at the trial, or police fails to arrest him, in that case, the magistrate may take another steps under Section 339B to held in absentia trial. And for holding in absentia trial of that particular accused, may publish an advertisement in newspaper giving a certain period of time to appear before the court and face the trial again. And after getting paper report or advertisement, the court may proceed to the next stage. One thing mentionable here, if the informant or the complainant become dissatisfied with the charge sheet, that is, if any one of the accused named in the FIR has been recommended to be exonerated, in that case, the informant or the complainant may file a Naraji petition to take cognizance against the person who has been recommended not to be taken cognizance. After examining the informant who filed the Naraji petition, if the magistrate becomes satisfied about the commission of the offense against whom a final report is filed, the magistrate again may take cognizance or pass an order exonerating, rejecting the Naraji petition. However, these are the interim measures may be taken by the magistrate, depending upon the situation of the criminal trial. Whenever magistrate deal with an Naraji petition and finishing all those steps, or whenever a magistrate dealing with taking steps for making the case ready for trial, after conclusion of those proceedings, may proceed to the next stage. What is next step? That is the framing of charge. Before framing of charge, whenever a case is ready for trial, the magistrate, if finds the case is triable by the magistrate, in that case, he may give it to its own file, or he may send it to the chief judicial magistrate for taking next steps. Or if the magistrate finds that the offenses involved are exclusively triable by the session judge, in that case, the magistrate will send the record to the session judge. After getting the record by the session judge, the session judge again will take cognizance under section 193 of the Code of Criminal Procedure 1898 and fix the record for framing charge. Framing charge is one of the stages of a criminal trial. At this stage, the session judge may take cognizance against the accused or may discharge some of them. And if any one of the accused being aggrieved by framing charge, he may prefer a revision to the Court of Session, or he may go to the High Court Division under section 561A to quash the proceedings. And thereafter, the formal trial will begin by recording evidence. And this is the another stage of a criminal trial, recording evidence. At this stage, the prosecution produces all the witnesses proposed by the investigating officer named in the column 6 of the charge sheet, one after another. After conclusion of recording of evidence of all the prosecution witnesses, or sometimes not remaining something who did not turn out yet after being summoned to the court may conclude the trial. And thereafter, the court may fix the record for examination of the accused. This is another stage of a criminal trial. At this stage, the court will draw the attention of the accused person to the incriminating part of the evidences led by the prosecution and wants to know whether they have any say or not. Generally, in our country, the accused person never say anything. And thereafter, the court asks the accused persons to say something as to their defense. And and lastly, the court may ask the accused person whether they will produce defense witness or not. If the accused persons express their desire to produce defense witnesses, in that case, the court will be fixed for the record will be fixed for the examination of DW. Or if the accused did not express their desire to produce DW, in that case, the record will be fixed for argument hearing. You know, argument hearing, another prominent stages of a criminal trial. And at this trial, at this stage, under section 265J, the prosecution will begin the submission to sum up the case and will bring notice to the evidence produced by it and he claim that the accused shall be punished with highest punishment. And thereafter, the defense will reply and stated its own case, bringing the contradiction and disparity of the evidences to the notice of the court. And by this way, the arguments will be concluded. And after arguments, the trial record will be fixed for pronouncement of judgment. This is the another and last stage of a criminal trial. At this stage, the court publish its decision in open court. And if the court finds the accused guilty, and if the accused is present at the courtroom, then and there the court taken into custody, taken the accused to custody to serve and commit to prison to suffer imprisonment. And thereafter, after delivery of judgment, the court may take steps to realize the fine if it impose fine upon the accused person. But generally in Bangladesh, no court take any steps to realize the punishment, though it is the duty of the court. However, after passing judgments, the convict may agree with the punishment, may prefer an appeal to the higher court. These are the different stages of a criminal trial, how a criminal trial proceed or roll down one after another. From this discussion, we may divide the criminal trial into three, and those are pre-trial stage, trial, and post-trial. Which are the stages included in pre-trial? Pre-trial includes lodging FIR, filing investigation report, taking cognizance, and sometimes dealing with Naraji petition, or sometimes making the case ready for trial. All those are included in pre-trial stage. And trial stage starts with the framing of charges against the accused persons. And it also includes the recording of evidence, examination of the accused under section 342, and arguments and delivery of judgments, pronouncement of judgment. These are the trial stages. And after trial, which is called as a post-trial proceeding, post-trial proceedings may be initiated either by the court or by the convicted person. What are those? The court may initiate or to realize the punishment, which no court initiate generally. And post-trial proceeding, as a post-trial proceeding, the convict may prefer an appeal. These are the post-trial proceedings of a criminal trial. So, however, the person who has interest to know about the trial procedure of criminal courts in Bangladesh, I try to satisfy your um, desire, desire, and I think I could have been able that if you know about the judiciary of Bangladesh, if you if you want to know about the judiciary of Bangladesh, court system and criminal trial and other trials, you can follow this channel, subscribe the channel. Thank you again for watching this video. And we are conducting bar professional training course in Bangladesh. Those who want to be a good lawyer, efficient lawyer within shortest possible time, um, you may be with us. You may communicate with us over the WhatsApp number given in the description box. We are the we are the sole institution in Bangladesh who are conducting the bar professional training course among the lawyers. Already, and thousands of participants are getting benefited from our courses. We have conducted different courses for last 20 years. If you want to be a good lawyer, as a sample, you can join our courses. Thank you again on behalf of the Badullah Academy.